Child injured at daycare in Ohio, what parents should do next. When you drop your child off at daycare, you trust the facility to keep them safe. So when your child comes home with an unexplained injury or tells you something happened, you may be left wondering what to do next. Was it an accident? Negligence? Abuse? Should you call the police? Should you report the daycare? Can you bring a civil claim? In this video, we'll explain what parents should do after a daycare injury in Ohio, how to recognize possible negligence or abuse, what evidence may matter, who could be responsible, how Ohio law treats these claims, and when you should speak with an attorney. If your child suffered a serious injury, permanent injury, or was abused at daycare, contact Piscitelli Law Firm for a free consultation. Piscitelli Law Firm represents families throughout Ohio and carefully limits the number of cases it accepts so its attorneys can dedicate the time and resources serious cases require. You can call the firm or visit getfrankgetjustice.com to learn more and complete an online evaluation. Step 1. Make sure your child is safe. The first priority is your child's immediate safety and medical care. If your child has suffered a serious injury, seek emergency medical attention. Even injuries that appear minor may require evaluation, especially when they involve the head, neck, breathing, loss of consciousness, unusual behavior, or possible poisoning or medication errors. Tell the medical provider that the injury may have occurred at daycare. Ask that the child's symptoms, visible injuries, and explanation of what happened be documented in the medical records. If you believe your child remains in danger, do not return the child to the daycare until you have addressed the safety concerns. Common daycare injuries. Daycare injuries can happen in many different ways. Common examples include falls from playground equipment, furniture, or changing tables, head injuries and traumatic brain injuries, broken bones and fractures, choking incidents, burns, drowning or near-drowning incidents, medication errors, unsafe sleep practices, injuries caused by inadequate supervision, injuries caused by dangerous or defective equipment, bites, bruises, or injuries caused by another child, physical, emotional, or sexual abuse. An injury alone does not automatically prove negligence. The important questions include what happened, whether the daycare followed safety procedures, and whether proper supervision could have prevented the injury. When an injury may be negligence. Daycare negligence may involve more than one person or decision. A facility may be negligent if it failed to properly supervise children, maintain safe premises and equipment, follow required child-to-staff ratios, properly train employees, conduct appropriate background checks, respond to a child's medical needs, follow feeding, medication, or sleep instructions, prevent foreseeable fights or dangerous conduct, properly investigate or report prior safety concerns, notify parents about an injury. Negligence generally means that someone failed to act with the level of care a reasonably careful daycare provider would have used under similar circumstances. A child getting hurt does not automatically mean the daycare is legally responsible. The evidence must show that the daycare or an employee failed to meet its duty of care and that the failure caused the injury. Signs of possible abuse or neglect. Parents should take concerns seriously when a child has unexplained bruises, burns, scratches, or other injuries, repeated injuries with inconsistent explanations, a sudden fear of a particular employee or location, major behavioral changes after attending daycare, sleep problems, regression, or unusual anxiety, injuries that do not match the explanation provided, signs of restraint or rough handling, a diaper rash, dehydration, or illness that appears to have gone untreated, an injury the daycare failed to report promptly. You do not need to prove abuse before reporting a reasonable concern. If you believe your child may have been abused or neglected, you can report it to the Public Children's Services Agency or law enforcement in the county where the child lives or where the incident occurred. Ohio's statewide reporting number is 8550H-CHILD or 855-642-4453. If your child is in immediate danger, call 911. Reports may be made anonymously. Talk to your child carefully. If your child is old enough to communicate, try to remain calm and allow the child to explain what happened in their own words. Ask open-ended questions such as, "Can you tell me what happened? Where were you when you got hurt? Who was there? What happened next?" Avoid repeatedly questioning the child, suggesting answers, or pressuring the child to provide specific details. If abuse is suspected, trained investigators should conduct the formal interview. Write down what your child says as soon as possible. Include the date, the child's exact words as closely as you can remember, who was mentioned, and any changes in behavior or physical condition. Document the injury and request records. Take photographs of visible injuries. Keep copies of medical records, bills, prescriptions, discharge instructions, and follow-up recommendations. You should also request a written incident report. The daycare's explanation of what happened, the names of employees who were present, the names of witnesses, information about when the child was discovered injured, any records showing when the parents were notified. Ask the daycare to preserve surveillance footage, attendance records, staffing records, and other documents relating to the incident. Do not assume surveillance footage will be kept indefinitely. Keep communications with the daycare in writing whenever possible. Save emails, text messages, app messages, photographs, and voicemails. Who may be responsible? Depending on the facts, potential defendants may include the daycare center, the owner or operator, an individual employee or caregiver, a parent company or management company, a staffing agency, a property owner, another responsible person or organization. A daycare may potentially be responsible for negligent hiring, training, supervision, or retention of an employee. However, each case depends on the evidence and the legal relationship between the facility and the people involved. If another child injured your child, the daycare may still face responsibility if inadequate supervision or unsafe conditions contributed to what happened. Criminal and civil claims are different. A daycare abuse investigation may involve law enforcement or children's services. That process is separate from a civil claim for compensation. A criminal investigation may focus on whether someone violated a criminal law. A civil claim may focus on whether the daycare or another responsible party caused harm and should compensate the child and family. A criminal charge is not always required before a civil claim can be pursued. Likewise, a criminal investigation does not guarantee that a civil case will succeed. Do waivers protect daycares? Some daycare facilities ask parents to sign waivers or liability agreements. Parents should not assume that signing a document automatically eliminates every possible claim. The language of the document, the type of injury, the conduct involved, and Ohio law may all affect whether the waiver matters. A waiver may not protect a facility from every form of negligence, reckless conduct, or abuse. Before signing additional paperwork after an injury or accepting payment in exchange for a release, have the document reviewed by an attorney. Ohio filing deadlines. Ohio generally requires claims for bodily injury to be filed within 2 years after the injury occurs. However, claims involving children may be affected by rules concerning minority, and a child's claim may have a different deadline from a parent's related claim. Claims involving childhood sexual abuse are governed by special rules. Ohio currently provides a longer time period for many claims based on childhood sexual abuse, with the limitations period generally beginning when the victim reaches adulthood. Because the deadline can depend on the child's age, the type of conduct, when the injury was discovered, and who is bringing the claim, parents should not wait to seek legal advice. What compensation may be available? Depending on the circumstances, a claim may seek compensation for emergency treatment, hospitalization, medical bills, future medical care, rehabilitation, counseling or therapy, disfigurement, physical impairment, pain and suffering, emotional distress, loss of normal childhood activities, long-term care or support, wrongful death damages, when applicable. The value of a case depends on the severity of the injury, the child's recovery, the need for future care, the evidence of negligence, and the impact on the child and family. No attorney can accurately determine the value of a claim without reviewing the medical records, facts, and long-term consequences. How a daycare injury claim works. A serious daycare injury claim typically begins with an investigation. An attorney may review the medical records, daycare communications, incident reports, photographs, witness information, licensing records, and available surveillance footage. The attorney may then identify the responsible parties, evaluate whether the evidence supports a claim, calculate damages, and communicate with the daycare's insurance company. If the case cannot be resolved, a lawsuit may involve filing a complaint, serving the daycare or other defendants, written discovery, depositions, expert testimony, settlement negotiations or mediation, trial. Some cases resolve without a lawsuit, others require litigation to obtain a fair result. What parents should avoid. After a daycare injury, avoid posting detailed accusations on social media, deleting messages or photographs, altering or editing evidence, signing a release without understanding it, accepting a quick payment as full compensation, allowing the daycare to pressure you into changing your account, repeatedly questioning your child in a way that may influence their answers, waiting to investigate because the injury initially seems minor. If your child was injured, neglected, or abused at daycare, you may have questions about what happened and what options are available. The most important steps are to protect your child, obtain appropriate medical care, document the facts, preserve evidence, and understand the deadlines that may apply. Piscitelli Law Firm represents families throughout Ohio in serious injury, permanent injury, and wrongful death cases. To speak with the firm, call today or visit getfrankgetjustice.com to learn more and complete an online evaluation. This video provides general information and is not legal advice. Every case is different.